So the things we're going to be talking about are the disciplinary procedures, grievance procedures, and dismissals. Now, all of these things are really applicable to your employed staff, so the employees you have at the clubs. We appreciate, however, you also have people engaged in other ways. You might have workers, you might have casual staff, you might have self-employed individuals, you might also have volunteers. So in respect of all those different roles, these things don't necessarily apply. However, we're going to touch briefly on the issue of employment status because it is a relevant consideration as to whether you really have a self-employed or a worker, or actually whether you have an employee in practice. So if we go on to disciplinary procedures, first of all, I'm going to warm you all up with a question, first of all. So do you have a disciplinary policy at your club? You can perhaps answer in the chat there, please.
So you've got a poll up there now. Do you have the disciplinary policy at your club? Yes, no, or don't know? If you could just put that in. If for any reason you can't see the poll, or you lose the polls throughout, please do put your answer into the chat function. But I can see people's answers are coming in now. So last chance to get that in, and we'll just shut that poll off, and I'll share the results with you. And Charlotte, 80% actually say that they do have a disciplinary policy at the club. We've got a couple that don't know, and one that doesn't have a disciplinary policy.
Well, that's music to my ears as an employment lawyer. It's brilliant that you've got policies in place. There is a requirement to have those in place under the Employment Rights Act. So when you are employing staff, it is important to get those policies in place early on. If you don't have a policy, or you don't know whether you've got a policy, find out. And as Tom already said, you can go onto the portal that has various documents on it, including a template disciplinary policy. So if you don't have one, you can access that on the portal. We move on to the next slide. I'm just going to talk you through, first of all, what the sort of disciplinary procedure looks like. We're going to come on to what are disciplinary issues and what potentially would fit the bill as a disciplinary issue where you might want to take action or potentially dismiss. We're going to start off with the procedure. Just wait for the slides to catch up with me. So the policy that we've got at Irwin Mitchell, which you can access on the portal, and I'm sure the policies you've got in place already, will need to comply with the Acas Code of Practice on Disciplinary Grievances and Procedures. So the Acas is a government organisation, and they put across guidance on issues like disciplinary and grievances. Now it's sort of voluntary guidance, if you like. However, there can be more serious consequences of not following that guidance. So it is important that your policy complies with the Acas Code of Practice. And those consequences are, if you are faced with a tribunal matter because you've dismissed somebody, or somebody's resigned and claimed constructive unfair dismissal because they've raised a grievance, if the tribunal find that either side, either the employee or the club, haven't followed those policies, and the Acas Code of Practice, they can award an uplift or reduction on any compensation awarded. And the uplift can be up to 25%, or the reduction can be up to 25%. So it is important to make sure that your policy is compliant. So if you're not sure, the policy on the RFU portal is compliant, so you can use that as your starting point. And so next slide. So I wanted to talk through some of the stages of a disciplinary policy, and this should be clear in your policy. But the first starting point is you have to need to work out whether you have got a disciplinary issue in the first place, or a potential disciplinary issue. Then it's to investigate, consider whether you need to suspend, and I'm going to come on to that in a little bit more in a bit. Once you've decided there is an issue that warrants a disciplinary hearing following the investigation, you'll need to write to the employee to inform them that there is a disciplinary hearing. So you need to give them some notice of that. And any evidence that you've collated in the course of the investigation, they need to have the opportunity to see that, so they can respond to that in the disciplinary hearing. The next stage is the disciplinary hearing itself. And then following that, you can make a decision. And the final piece of the puzzle in the procedure is the appeal stage. So once you've made that decision and applied that sanction, the employee normally has a right, or should have a right to appeal against that decision. It's worth checking your policies. Sometimes, occasionally, in disciplinary policies, there's a second right of appeal. Generally, we wouldn't advise you to have that, but it's worth just checking what your policy actually says and follow that procedure in your policy. We move on to the next slide. I've got another question, just to continue just to warm you up a little bit. So Mr. Wilkins is also, so Martin, thanks for bringing that up. Thank you. Martin, did you want to read through the question, or do you want me to?
Yeah, certainly. So Mr. Wilkins is the line manager for Miss Stevens and works in the club's bar. On a particular busy Friday night, he saw Miss Stevens pocket a substantial tip received from a customer who specifically stated that it would be for the whole team's hard work that evening. Who should conduct the investigation? Should it be Mr. Wilkins as the line manager? Should it be a colleague that started 3 weeks ago and is still in training? Or do you think it should be the line manager for the catering team? Let us know. That poll is with you now. You should be able to move that poll around if you want to read it again. Don't worry, go with what you think. It's not a test tonight on any of these polls. For any reason, if you can't see that poll, please put your answer in the chat function. So I can see answers are coming in now. So I'm going to give you a last bit of chance to fill that in, or who you think should conduct that investigation. So last few seconds, and I'm going to end that poll now. And Charlotte, I'm just sharing them results. So the majority think it should be the line manager for the catering team. Charlotte?
Fantastic. Thank you, Alex. Yes, I'd agree with that. The line manager for the catering team. I don't know whether you know why. Feel free just to put it in the chat if there's a reason behind that line of thinking. So a few of you put the line manager, and I mean, that is a bit of a difficult question, because you would normally think it would be the line manager, the next kind of in line, who would be looking into this matter. But again, if you know the reason why it wouldn't be the line manager, perhaps just put that in the chat now. I'll move on to the next slide just to give you a chance to do that. See if I can see any answers. Line manager was a witness. Exactly, it's exactly that point. So I'm just going back to the wrong slide. It's exactly that point. So it needs to be somebody independent. It obviously shouldn't be the junior, because it needs to be somebody more senior. So the line manager of the catering team would normally be the next appropriate person you'd expect to deal with the matter. Obviously, you might have different names in the club, and it depends on who the employee is, but it's generally somebody more senior to the employee involved, who is not, who is independent. So they haven't been involved as a witness. He would be the appropriate person to carry out that investigation. And then sort of similar applies in respect of the actual hearing itself. So you would not normally have the same person who's done the investigation carry out the disciplinary hearing if it gets that far. So somebody else who's independent, and again, typically more senior. So it needs to be appropriate to who you've got available, but typically you're kind of looking to escalate to a more senior level when you get from investigation, disciplinary, appeal. I'll move on to the next slide. Yeah, so here I've just put some considerations when you're thinking about who can investigate, which more or less reflect that. So just use that as a bit of a reminder there. On to the next slide. So in terms of conducting an investigation, it needs to be started quickly, as soon as possible, while the evidence is fresh. I think if you carry out an investigation 3 months after an incident, it's probably not going to be a fair investigation. So do it promptly. Record your findings in writing. Cover all the relevant materials. So any kind of documents that you need to consider as part of the investigation, collate those together and think about who the relevant witnesses are and take their witness statements. In investigating a matter, it's really important to be aware that you should look for evidence that both supports and contradicts the allegations. You're looking to carry out a fair and balanced investigation. So look at it from both those sides. And then you proceed to the next stage only once you've decided you've got a case to answer. and it's necessary for a disciplinary hearing. It may be that you carry out an investigation and there's not enough evidence really to substantiate going any further. So you need to consider the evidence before moving forward to the next stage. The golden rule, as we put here, is generally the more serious the allegation, the more detailed the investigation will need to be. It will, however, depend on the nature of the allegation in the first instance. We move on to the next slide. I've just put here some ideas as to how to make a plan when you're investigating. So think about what facts need to be established for it to move any further. Who do you need to interview? How do you arrange those appointments with the witnesses? Who's available? People on holiday. So have a bit of a plan there as to kind of what you're going to do, how you're going to do it, and do it within a sort of timely, in a timely manner. So within a reasonable period. Move on to the next slide. In interviewing a witness, I've also got some further tips for you here. Explain the purpose of the meeting, who's present and why, and explain to them why you're getting their statement in the first instance. So that's really important. It's probably a good idea just to make a note of some questions you're going to be asking to the witness. That said, I think it's really important too that you're prepared to go off script as necessary. Don't stick rigidly to a script. So if somebody says something in the course of you interviewing them that you need to ask them more questions about, do that, even if it's not in your script. In terms of taking the statement, you're looking for the facts. So don't listen to, try to discourage them from talking about rumours and what they've and hearsay. You want to understand, what did they see? What do they know? And if they say somebody else might have more information, then you might need to go away and interview that other person. And as I said earlier, you're looking for corroborating and opposing evidence. So it's not just evidence that supports the allegation, it's also any evidence that opposes it, which may then decide your course of action is not to take the matter any further. On to the next slide. I think this is just quite an important point, which comes from a case. Essentially, in some cases, it will be a closed book situation. The employee is pretty much caught in the act. In that situation, the evidence that you need to collate as part of the investigation is going to be fairly minimal. However, if it's somewhere where there's lots, there's lots of avenues of inquiry, you need to be prepared to do that. So just be aware of that when you're carrying out that investigation. Move on to the next slide. So I mentioned briefly suspension and when you should suspend. So suspension isn't reasonable in all circumstances. I think it really needs to be as a protective measure. So if there's a good basis because you're worried about the damage the employee could do, you're worried about them interfering with evidence, that all may be good reasons why you're suspending someone pending the outcome of the investigation. It's really important that it's not just a knee-jerk instant reaction to a serious allegation. So not all serious allegations will warrant suspension. You need to sort of set out any suspension in writing. It's really important to make it clear to the employee that it's not a disciplinary sanction, and keep it as short as possible so that it's only whilst you're trying to get to the bottom of things that they are suspended. Keep it under review if it needs to go on for a bit longer because the investigations take a bit longer and it's necessary to keep them in suspension. And make sure that you continue to pay them as usual during periods of suspension, so you can't have unpaid periods of suspension. So moving on to the letter inviting the employee to a disciplinary hearing. So once you've done the investigation, you decided there's a case to answer, you need to invite the employee in writing to a disciplinary hearing. Set out the date, the time, the place of the hearing, who's going to be there. Explain that it's a disciplinary hearing. Explain the allegations and how they're framed is really important. Essentially, you have to kind of give the details so they can respond adequately to those allegations. So it is really important as to how you frame them and as to the fair reason, potentially if you're going to look to dismiss, that framing of the allegations is particularly important. If in doubt, always get legal advice, and we can obviously help you with kind of framing those allegations in the best way. You need to set out in the letter the possible consequences of the disciplinary hearing. So that may just be a warning, maybe a final written warning, it may even be dismissal. So consider what the outcome is going to be without making that decision at this stage, and give yourself scope to kind of make the outcome the more serious one that you potentially could go up to if the circumstances warranted it. An employee's got the right to be accompanied at a disciplinary hearing, so you need to let them know that in the letter, and the right is to have a colleague or a trade union rep with them at the meeting, so you need to give them that option. And they've got a fairly, as long as it is just a colleague or a trade union rep, it's up to them to decide who that colleague or that trade union rep is. Any evidence that you've collated should be presented to the employee at this stage. Again, it's so they've got an opportunity to consider and so they can respond to that at the hearing. And as I said earlier, it's really important that sufficient information about the allegations is set out in the invite to the disciplinary hearing. So moving on to conducting the hearing. So we've put on a fact sheet here just to kind of help you if you are conducting a hearing as to things to consider. So you want to introduce it, you want to examine the evidence, you want to understand the employee's response to that evidence. You also want to understand any mitigation from the employee. So ask the employee, what's their response to? Is there anything you need to take into account which might influence the outcome of the disciplinary hearing? It may be during the course of the hearing that there are further matters that come out that you need to investigate more. So if that is the case, that's absolutely fine. Before making your decision, you might pause things, go away, investigate, and then reconvene the disciplinary hearing. So just be prepared to investigate further if that is necessary. Summarise what you've discussed at the meeting at the end, and then I put adjourn and deliberate. So how long you adjourn for might depend on the kind of situation. It may be that you can have a short adjournment, return to the meeting and make your decision. More often than not, you might have to go away, carry out a bit further investigation, and then reconvene it perhaps the next day, the next couple of days before making your decision. Don't adjourn for too long, but equally adjourn as appropriate so you can consider the outcome and consider any further investigation and consider the mitigation. It's always best to have an adjournment rather than just making your decision instantly at the hearing, because that shows that you've properly considered what the employee has said. And then finally, obviously, you reach your decision. And move on to the next slide. In your decision, there will be a variety of options available to you, depending on the situation itself. It may be that you issue a warning. Sometimes you would start from a warning and then you escalate to a final written warning, and then it's eventually dismissal. However, it's not always necessary to go through the series of sanctions to get to the more serious outcome. So if a matter is sufficiently serious, it may be that you go straight to a final written warning. Equally, it may be you go straight to dismissal if it is even more serious than that. Get legal advice if you're not sure. We would help guide you on what the potential outcome should be and what would be a fair outcome. Generally, for a first offence that's not too serious, you wouldn't normally dismiss. You'd give the employee the opportunity to not repeat that behaviour or repeat that issue. So unless it's a really, really serious issue, you wouldn't normally jump straight to dismissal. You can look at previous warnings. So if they've been issued with a previous warning and that warning hasn't lapsed, you might need to escalate it. What I mean by lapse is have a look at the policy, because it would normally say that when you issue a warning, it's live for a period of 6 months or 3 months, and you would have put that in the previous outcome of the last disciplinary. So you need to look back as to kind of what the period for that previous warning was. If that warning has expired, it's not normally appropriate to refer to that and escalate based on that expired warning, although it may be relevant to some of the background. So a bit of a technical point there, but again, if in doubt, get some legal advice on it. And then finally, we're going to move on to appeals. So I'm just going to pass over to my colleague, Poppy, who's going to talk you through appeals.
Thank you, Charlotte. So once the disciplinary process has been followed, you've decided on a sanction, the employee has a right to appeal. With regards to the appeals process, similar procedural steps to those in the initial stages need to be taken. So again, you need to give notice, the employee has the right to bring a companion or trade union rep, etc. So just for some background on appeals, appeals are a necessary part of a fair procedure, but if the employee wants one, they need to ask for one. As Charlotte has already mentioned as well, usually procedures only allow for one appeal, but you should check your policies just in case they provide for more, because sometimes they do. When asking for the appeal, the employee should set out their grounds in writing. Now, your policy can put in place a time limit for them to bring an appeal, so sending you those grounds. For example, our template policy gives employees 5 working days to do so. However, you may need to be a little bit more flexible regarding this timeline, so don't expect to stick to it too rigidly. This is just because if you dismiss someone and they didn't get the opportunity to appeal, you increase risks of an unfair dismissal claim. So the appeal should be heard without a delay, similarly to the initial hearing, and it should be conducted by an impartial manager. So that is someone, again, that's not previously been involved in the disciplinary process and someone that is of appropriate seniority. This is just so that if they feel they need to overturn the initial sanction imposed, they're able to do so, and they feel that they can if it's appropriate to do so. So Charlotte, if we could just move on to the next slide, please. Thank you. So the appeals manager may uphold, overturn, or reduce the original sanction, and in making their decision, they should consider whether the original outcome was fair, and if it's clear that it wasn't, it should be changed. Now, under some circumstances, it may be necessary to conduct further investigation to find out more about before making that final decision. So that would include circumstances where you need to look at new evidence, for example, which is raised by the employee, or where there are new witnesses. And in the event that any extra investigation brings up any substantially new evidence or more serious allegations against the employee, you need to start the investigation again. And that's just because without going through the entire process again, appeals shouldn't be used to impose higher sanctions than those already imposed on the employee. They're really just looking to see whether the sanctions were fair, and if not, to reduce them. Which leads me on to the next point, which is that you may also want to investigate again if there are issues or alleged issues regarding how the investigation was carried out. So what happens if the employee successfully appeals but was already dismissed as a result of the original investigation? Well, in short, employment is automatically revived. And so what this means is the employee should be treated as though they were never dismissed, and they should be entitled to any pay they lost in the time between the dismissal and the appeal decision. So that's all from me. Thank you very much. I'll hand back over to Matthew now, I believe, who will be discussing dismissals in more detail with you.
Yeah, well, hi, good evening, everyone. My name is Matthew Irvin, and I'm going to be looking at terminating someone's contract of employment, or firing them in the language of Lord Sugar. What I thought I'd first touch on, though, and we are having quite a few queries on this sort of thing, is employment status. Charlotte mentioned it as well, and it is important to sort of know who you're dealing with at the outset, and especially when you're coming to terminate a contract. And there are technically 3 categories. Someone can be either an employee or a worker or self-employed, which isn't there. But effectively, if someone's self-employed, they've got a bit more freedom than an employee. An employee normally has a contract of employment. There's an element of control exercised by the employer. There's an obligation for the employer to provide work, and the expectation that the employee will do that work, and it should be that individual employee. Whereas if someone's self-employed, the contract is to provide services. They're usually left to their own devices, and and in theory, they can send a substitute to do the work or to provide the services in their place. And a worker is a bit of a hybrid in between, really. They have fewer rights than an employee, and fewer again. A self-employed person has fewer again. If we can go on to the next slide, it's obviously helpful to have a contract in place so that both parties understand what the position is. But it is important to bear in mind that at the moment, tribunals are increasingly looking at what the reality of the situation on the ground is, and not necessarily just what the contract says. And so that's where employment status is important, and this could be a topic in of itself. It's not really the focus of tonight's session, but worth flagging and something to be aware of. For example, employees are the ones that have got the rights to bring an unfair dismissal claim, whereas obviously self-employed people don't have that. So turning to the question of dismissals, and one of the first things that we always think should be considered is how long have you actually employed this person for? Someone needs 2 years continuous employment before they can bring a claim of unfair dismissal in a tribunal. And so it's worth having probationary periods so that you can assess how someone's getting on. But in some ways, you do have those first couple of years to make your decision. Having said that, you do have to be aware that a claim for discrimination is, and that could be in relation to something like sex, age, disability, or race. That claim can be made right from the outset. And so you would need to bear that in mind, and whether there's any risk of that when you decide to dismiss someone. On to the next slide, please. And that when it comes to dismissing fairly, there are two elements. You first have to have a fair reason, and then you also have to follow a fair process. And that is in the circumstances. And someone's asked about whether it's taken into account the size of the organisation, and it is. You know, large organisations will be expected to have to follow better processes, but you can't say we're a small organisation, do we have to follow no process at all? You do need to follow a process. And looking at these 5 potential reasons, just to try and explain them, conduct is usually when an employee has done something. They've done something inappropriate or wrong, or that they shouldn't have done. Whereas capability is the second reason there, and that's when someone's not really able to do their job. And that could be because they're not performing very well, or it could also be if they've been off long-term sick. Redundancy, most people have heard of that. It's when there's less work of a particular kind, or when a job role is no longer needed. And illegality is quite a technical one. It's when someone can't legally do their job. They might be banned from driving. They might not have the required visa to actually work in the country. And the final one there is a bit of a catch-all. It's called some other substantial reason, and it can apply to certain situations, which we will have a look at. If I move on to the next, this is the second part of dismissing fairly, and it is the process. And as I said, it does depend partly on the size of an organisation, but the procedure to follow will also vary a little bit according to which is the reason that you're going ahead with a dismissal for. So, for example, with conduct, as Charlotte has mentioned, you would need to investigate the situation. If there's a case to answer, that would move ahead to a disciplinary hearing where someone new would hear that and come to a decision. And then, of course, you do need to remember the right to appeal, again, heard by a separate person. Capability, the process is potentially slightly different. If someone's not performing very well, you would normally need to tell them that, and you'd normally need to give them a chance to improve, and that might be under a performance improvement plan. And if they didn't improve after you'd set specific targets for them to meet, then you do hold a disciplinary hearing, but that's more likely to be a first warning, then a final warning, then dismissal. You wouldn't normally go straight to dismissal if someone's not performing well. And if someone's off sick, that again could come under capability. But in that situation, you'd be looking to obtain some medical evidence to support your decision. And that could be GP notes, an occupational health report, or a hospital consultant's report. And if that report suggests that the employee is unlikely to be able to return to work in the foreseeable future, then that probably gives you the argument and the reason to say that you may have to dismiss. But again, you would need to hold a hearing, and again give someone the right to appeal against that decision. The next one is in relation to redundancy. And the thing to remember with redundancy is consultation. That is the key thing. It sometimes sounds a bit counterintuitive to an employer that thinks, well, we need to make the decisions here. But it is an important part of the process. You need to consult with employees. So consult on the proposed redundancies, and it gives employees a chance to come up with suggestions or other proposals. It may be they were thinking of cutting down their hours, and that might save you a formal process. But if you don't want to consult, then just remember P&O ferries and how not consulting seems to have gone for them. Once you've consulted, you can then say, well, we do think this planned redundancy should go ahead, and then you move on to the next stage of your process. If, for example, you're reducing, you've got 5 people doing a certain role and you think you only need 3, then you would need to decide how to select the 3 to stay on and the 2 to go. And you would need to use selection criteria, which are ideally objective. And then you would score the people against those objective criteria. And in that example, the bottom 2 would go. One of the things to think about with that is people say, oh, we want a team player, and everyone kind of knows what that means, and is what you want, but it is quite difficult to sort of score and show how you've arrived at that score. So it just goes back to trying to get criteria that you can see are objective. And then the final thing on redundancy that you need to remember is that you do have to consider if you've got any alternative roles or vacancies within the business or within the club. Because if you do, then you may have to offer those to the people that have been selected for redundancy. Illegality and some other substantial reason, similar processes, you would still need to investigate and hold a hearing, and again an appeal. The main idea with a procedure is to give an employee a chance to be heard, a chance to state their case, because it's kind of a sort of principle of natural justice that someone should get the chance to have a fair hearing before a decision is made. So just that's the thing to bear in mind on the process side of things when handling a dismissal. Next one, please, Charlotte. Just briefly, I did mention some of the substantial reason and a couple of examples of where that's been used. It's a bit of a catch-all and it's not always the sort of easiest approach. But for example, if someone's gone to prison and it's going to be a lengthy service time in prison, and that would be potentially some of the substantial reason. It has been held to be fair to dismiss with a big personality clash, which led to a complete breakdown of the working relationship. That has been held to be some of the substantial reason and was a fair dismissal. But again, I think with that kind of thing, I would want to take some advice before going down that route. And just to mention that there are certain things that can be deemed automatically unfair if the employee can demonstrate that that was the reason that they were dismissed. And And that would be, for example, making a flexible working request if you dismiss because someone's on maternity leave or pregnant, if they're a trade union member, or they assert a legal right, for example, wanting to be paid the national minimum wage, or a whistleblowing type situation. In that situation, it could be deemed an automatic unfair dismissal, and they wouldn't need the 2-year service if they can demonstrate that. So moving on, we're now going to give you a chance to sort of test your knowledge and to have a little think. The first scenario is up there on the slides. Hang on, I'll read it out. Rachel is a bartender. Hang on, I'm just going to try and move the...
I can read it for you.
Do you mind, Martin? Thank you.
Rachel is a bartender at the Rugby Club's bar. Her manager has noticed that her sales for a busy Friday night do not match the amount collected in the till. It transpires that Rachel has been making errors when putting purchases through the till, often selecting the wrong drinks. Is this a performance or a conduct issue? Let us know your thoughts in the chat, please. In the poll. So again, Rachel's the bartender. A Friday night do not match the money collected in the till, and it transpires that Rachel has been making errors when putting purchases through the till, often selecting the wrong drinks. Is this a performance or a conduct issue? Let us know what your thoughts are. You can do that. So I'll end that one now. I'll share the results. So Matthew, most of them think it's a performance issue. 94%.
Yes, that's right. I think sometimes the tendency is to think, oh, has this person stolen from us? In which case, if there was evidence of that, if she was actually stealing or taking the money out of the till, then that could be a conduct issue. But in this situation, I think you're right. It's more to do with performance. She hasn't possibly been trained. She's just making errors, and it's something that she would need to be picked up on. But yeah, that's not a conduct. It is a performance issue. Can we go on to the next one, please? I can see this one, Martin. So thank you. I'll read this one out. Mr. Crouch is a rugby coach who's reimbursed for his petrol expenses when travelling to away matches. A team player has alleged that Mr. Crouch has been dishonestly submitting his private petrol bills for reimbursement. He strenuously denies these suspicions. How sure does Mr. Crouch's boss have to be that he can fairly dismiss Mr. Crouch? How sure does he have to be that he's been dishonest to fairly dismiss? So this is a sort of a test of what's the test? Is it on the balance of probabilities? Is it beyond reasonable doubt? Or is there no standard of proof that applies?
The poll should be up on your screens, and you could just answer one of those three options there. So on the balance of probabilities, beyond reasonable doubt, and there's no standard of proof that applies. We'll just wait for those answers to come through. Alex, is there anything coming through there now?
Yeah, last few seconds. Majority of people have completed now. So I'll end that one there and share those results with you. A mix of responses here, but the majority, 53%, have gone for beyond reasonable doubt.
Right. Well, it is actually on the balance of probabilities. So it's a lower standard than the test of beyond reasonable doubt, which is more, well, that's applied in a criminal trial. There has to be evidence beyond reasonable doubt in a criminal trial. In this setting, just bear that in mind. It doesn't need to be more than on balance that you find someone guilty of the allegation. So that is worth bearing in mind as an employer. If we go on to the next one. Now, let's say that on balance there is evidence of Mr. Crouch being dishonest. In that situation, do we think it would be reasonable to dismiss? This is a yes or no.
So that should be with you now. What do you think? Yes or no? Would it be reasonable to dismiss? Let us know your answers. If for any reason, like I say, you can't see that poll, do give us your answer into the chat function. But I can see the results and people are managing to complete it right now. So last few seconds, make your answers, please. And we will cut it off there. And so the majority, 63%, are saying yes.
Okay. Well, that's interesting. It's a little bit divided. The majority of you are right. I think it would be within the range of reasonable responses. That's the test. It's a tribunal has to consider whether that is within the range. And it doesn't have to mean that every single employer would dismiss. And effectively, to be outside that range, it's almost, well, no employer would dismiss in those circumstances. And I think for dishonesty, that is something that is serious enough that if there's evidence of that, you can dismiss in that situation, and that would be within that range of reasonable responses. And just going on to the last example or scenario, Martin, would you mind taking this one, please?
Yeah, that's not a problem. So you are the club manager. A few players from the club have approached you, expressing their frustration with the coach, Mr. Smith, who is always late to training on a Saturday morning. And when he does finally arrive, smells of alcohol. As a number of players have approached you now, you take the decision to dismiss Mr. Smith. Would dismissal be fair? Yes or no? Let us know your thoughts. So as a number of the players have approached you, you take the decision to dismiss Mr. Smith for always being late and smells of alcohol. Would it be fair to dismiss? Let us know your answers. I can see that they've come in now, and the majority of them are saying no, 88%, Matthew.
Okay, well, I think the majority of you are right there. It's one of those ones where I think if on the lateness side of things, you would want to give someone a warning first. I don't think being late is sufficient on its own or on the first offence, so to speak, to go straight to dismissal. The alcohol side of things, potentially a bit more serious, but again, I think you probably want to investigate. It may be that he's gone out late on a Friday night and has been drinking. It's not great that it's happening on a regular basis, but I think to go straight to dismissal would probably be just outside that range of reasonable responses. It might be that you go for a warning on this one. I hope that's helped a little bit. I'm going to hand back to Charlotte, who's going to deal with some grievances, and then hopefully we might have some time for some questions.
Hopefully there aren't any grievances just yet, but I am going to deal with the grievance procedure. So what is a grievance? That's what I want to start off with. A grievance is any concern, problem or complaint that an employee raises with their employer. So it doesn't necessarily have to be in writing. It just needs to be concern that's brought to your attention, and doesn't need to be said that this is a grievance. So if you get notification from the employee that they've got a concern, at least raise the question with the employee, would you like this to be treated as a grievance? If you haven't got a grievance policy, again, one is available on the RFU portal. But if you've got a disciplinary policy in place, you've probably also got a grievance policy. It needs to be, again, in line with the Acas Code of Practice, which again, the one on the RFU website is, but it's worth just checking if you've got your own policy. Move on to the next slide. So the golden rules when you're dealing with a grievance is deal with it promptly, deal with it fairly, be consistent, and follow the Acas Code of Practice. I put in here some examples of more serious things that can be raised in a grievance. So grievance can cover a whole range of things, from a very minor issue to a much more serious issue. If the grievance contains something that looks like discrimination, that's where there is perhaps greater risk of a claim. So it may be that it needs to be investigated more thoroughly. It may be that you need to take disciplinary action off the basis of that grievance. So once you've investigated the grievance and made a decision, it may be that you need to take some action against any employees involved in those allegations. So I put in here some examples which might potentially be classed as sort of discrimination. So name calling, banter at work, could be bullying, could be discrimination. A grievance about somebody who's made a flexible working request and this is refused, and it poses difficulties for them in their family situation, that could potentially give rise to a sex discrimination claim. And there's another one about somebody who's diabetic, who's concerned about being asked to work overtime at short notice and says no because they're diabetic and is sort of treated a bit less favourably. So that's another situation where the fact that they're diabetic ticks the boxes of having a disability, therefore could be something which you need to take more seriously. We've also put in here examples of whistleblowing. So whistleblowing is where somebody's complaint or allegation relates to a criminal offence, a breach of a legal obligation, a miscarriage of justice, health and safety issues, environmental damage, or attempt to conceal one of these. So with whistleblowing, potential claim that can arise is a whistleblowing claim, particularly if they're subject to detriment or dismissal as a result of the concerns that they've raised. So if somebody does raise concerns of that nature, it does need to be taken more seriously. It may be that you have a separate whistleblowing policy in addition to your grievance policy. So it is worth checking that. And there may be slightly different procedures which you need to follow in dealing with that matter. So just be aware, look out for kind of what's in the grievance. Again, if in doubt, get some legal advice. We move on to the next slide. So this is reflected in our template policy, but it's probably reflected in the policies you've got in place. You've already got your own policy, is the procedure for dealing with a grievance. Normally, you'd have the option to deal with a grievance informally, and that procedure normally involves raising it with the line manager, having a discussion. That's the end of the matter once it's been resolved that way. For those less serious concerns that are raised, the formal procedure may be the first step. If you're in doubt and you think the issue is a bit more serious, it may be sensible, even if you say that you can go for the informal procedure, to at least offer them the option of the more formal grievance procedure if they want to do it. Equally, if the matter isn't resolved through the informal procedure, then you'd have to go through the formal procedure. I've just summarised here what the formal procedure involves. So it's you raise the matter formally in writing, there's an investigation, there's a meeting to discuss the grievance, decision is made in respect of the outcome of that grievance, and the employee has the right of appeal. It may be, like I said earlier, if it's very serious concerns, there's a finding in the employee's favour, that you need to then take disciplinary action potentially, or do other measures. Sometimes mediation might be an outcome of a grievance procedure, because where there's been a bit of a relationship breakdown between parties, you might decide, we haven't found enough here to uphold your grievance, but we accept that there's been a bit of a relationship breakdown. Therefore, we propose a mediation to resolve this matter. So move on to the next slide. Where you are able to take an informal approach, there probably are some benefits of this. The employee may feel that they've got some control over the process. It's a much quicker way to resolve it. It can nip it in the bud. potentially involve less senior management time. So I think you do need to think about, is this an option? Is it an option for dealing with it informally? And if it is, it can be the best option available to you. But like I say, if the informal approach doesn't resolve it or the issue is sufficiently serious, it would be appropriate to take it to the next step, which is that formal grievance procedure. So with the formal grievance procedure, you would invite the employee to a meeting to discuss the matter, allow the employee to explain the grievance. So sometimes in grievance notifications, there's not a lot of details. So you need to have the meeting to understand the issue with the employee. It's probably a really good idea to ask them how they want it resolved, because that is another way that you can get to a conclusion that is to all parties' satisfaction. It may be that you need to do further investigation after having that grievance meeting because you've got some more detail about it. If you do, be prepared to adjourn the meeting to do that further investigation. And also, if you've got all the information, be prepared to adjourn so you can consider the appropriate outcome. Like the disciplinary procedure, the employee has a right to bring a colleague or a trade union rep along to that meeting with them. And normally you'd have somebody there independently to take on behalf of the organisation, the club, to take a note of what is being said. And that also applies to the disciplinary procedure. You might want somebody to take a note at the disciplinary hearing to record what was said. Once you've made your decision, it needs to be confirmed in writing to the employee without unreasonable delay, and offer the employee the right to appeal. And include details of any action that you intend to take to resolve the grievance if you found in the employee's favour. But like I said earlier, even if you haven't found in the employee's favour, the grievance procedure can be a bit of a fruitless process in that it's just a procedure you have to go through. And it may feel a bit a disappointment, I suppose, to the employee who's raised the grievance. So there's always merit, I think, in trying to find a solution that helps the parties move forward. So if there is something you can offer, even though you haven't upheld the grievance, to try and appease the situation, it's worth considering. Now I've got some more headaches for you. So if we could bring up the poll. And Alex, do you want to ask this question?
Yeah, so Sarah resigns from the club, and in her written resignation, she includes a throwaway comment that her reason for leaving is that she is being bullied by a line manager. Should you deal with this as a grievance? Yes or no? Let us know your thoughts. So the full one of this, luckily, is managed to fit into the poll on this one, so you can read it there. But let us know what you think. Should you deal with this as a grievance? Yes or no? I can see the answers coming in. Just a few more to just answer. So let us know what you think, yes or no. So it doesn't matter if you get it right or wrong. We won't hold you to it. So yeah, I'm now going to give a final little chance before finishing this one. I'll end it there. And Charlotte, the majority are saying yes, 80%.
Okay.
Should.
Fantastic. So yes is probably the best answer here. So for those of you who said no, you're not necessarily wrong, because actually the grievance procedure is available to employees. So once you've resigned, you're no longer an employee. However, there's probably merit in investigating it, because the employee could potentially bring a claim based on the concerns they've raised. So if you can try to bottom out what happened through a grievance procedure, try to resolve it to the employee's satisfaction, that may be a way to mitigate against the risks of the employee taking things further. So I think there's generally merit, even with an ex-employee, in listening to their concerns, dealing with it through the grievance procedure. Obviously, if they left a long time ago and then they get in touch, I don't know, a year later with a grievance, I think that situation, it's probably not very appropriate to go through the grievance procedure. But if it's very recent, off the back of them resigning, I think it would be sensible to look into it further. And there's some quite serious concerns in this one, so being bullied by the line manager. So it may be that disciplinary action needs to be taken. So you need to at least get to the bottom as to what happened there to determine if there's been any wrongdoing and whether any further steps need to be taken. we move on to the next question, I've got another scenario for you. So hopefully that's going to come up on the poll in a minute.
So that's with you now. So Jim submitted 10 serious formal grievances over the past 5 years, alleging racist behaviour by his teammates, raising complaints about how his grievances have been handled, and complaining of victimisation. All of the grievances have been rejected, but each has taken significant time and resources to investigate, and there is concern that this employee will continue to raise groundless grievances. Do you need to investigate Jim's future grievances? Yes, no, or it depends. Let us know your thoughts. Can see them coming in. There's sort of two modes of thought on this one, it seems. So just give you the last few seconds to get your answers in. Thank you very much for those. I'll end the poll there. And it is literally 50-50. It's
50.
yes, and it depends.
Brilliant. So the answer is really that it does depend. So I think 50-50 response probably reflects that as well. So it depends. There has actually been a fairly recent case on exactly this issue, an employee who raised grievance after grievance after grievance. And the case involves an employee called Mr. Hope. And I always say to employers, this might give you some hope if you've got a serial grievance raiser. So in that case, the employee produced a report where they'd made some comments involving a colleague, and they were looking at disciplinary action against the employee in respect to those colleagues, in the comments that were made, sorry. The employee raised a grievance about that, and subsequent to that, they believe they've been excluded from meetings, so they raised a further grievance about being excluded from meetings. Now, before those grievances were properly concluded, the employee raised further grievances. The employer gave this employee the opportunity to have those grievances heard at a grievance hearing. The employee then decided that they perhaps didn't want that to happen, but they wanted to reserve their grievances. The employer said, well, that's not appropriate. We can't have that situation. We need to get a conclusion to this matter. In which case, as a result, the employee raised that grievance. And this happened. In fact, there were 7 grievances, I think, over a period of 13 months. So quite a lot of grievances. And almost they involved the same situation. They've been excluded from meetings, and the employer hadn't had the chance to properly hear those grievances, because before they did that, the employee raised another grievance. So in that situation, the employer offered a final grievance meeting to resolve all of the issues, and the employee refused to attend. The employer, further to that, took disciplinary action as a result of the employee's behaviour, which it considered to be vexatious in the way that it was dealing with the matter, and the employee was dismissed. Now, the employer then had to face the tribunal claim, and it was found that the employer in that instance was reasonable in dismissing the employee, not for raising a grievance, but for the manner in which they had raised so many grievances that it impacted on a breakdown of the relationship between the parties. Now, that is perhaps quite an extreme example, and it's not going to give you the green light in all cases to be able to dismiss an employee who's raised a grievance. So I think in the first instance, you need to treat each grievance as a genuine grievance. They may be in relation to different matters, and give the employee the benefit of doubt, listen to their concerns and address them. But if you are in a situation where you're faced with an employee who just won't let it go and keeps raising those grievances, get some legal advice, because there may be some options available to you to try to get another resolution to it. I think we've got a final slide for you now. So we move on to the next slide. I've got another question. So that should be coming up from the poll from Alex. Thank you.
So this is your final one for this evening. Thanks for joining it. You are Debbie's line manager. During a drink after an event with a number of people from the club, she mentions that her workload is significantly higher than her colleagues, whom you don't manage, that she is fed up with it What should you do? Treat this as a grievance under the company's grievance policy. Assume that Debbie is just letting off a bit of steam. Ask Debbie to put her complaint in writing, or wait until you're both at work and ask Debbie whether wishes to raise the grievance about the issue. So let us know your thoughts on this one. Is it treat this as a grievance under the company's grievance policy? Assume that Debbie is just letting off a bit of steam in the pub. Ask Debbie to put a complaint in writing so that you can deal with it, or wait until you're both at work and ask Debbie whether she wishes to raise as a grievance about the issue. So I can see majority have come in now, and there's a clear winner on what people are thinking, which is wait until you are both at work and ask Debbie whether she wishes to raise a grievance about the issue.
Fantastic. That's a great note to finish on that case, because I would agree with that answer. I think the context is important here. You're the line manager, so she's raising a concern with you, but you're in a social setting, you're not in the workplace. I think it's still important that you address it when you're back in the workplace, because she's disclosed something to you which is serious. So not appropriate in the social setting, not appropriate just to ignore it because it's in the social setting, but appropriate to bring it up when you're back in the workplace and see if there's a genuine concern that she wants to be properly addressed. That brings us to a conclusion of our training today. If you've got any questions, we're going to try and answer a couple of those now. I think we've got some time. Alex, Martin, have you got a few minutes just to answer some of these questions, do you think?
Yes, Martin's going to come on.
Well, first of all, thanks Charlotte, Matthew, Poppy, thanks so much for that. I realise there's this quite there's lots of complex areas here, and actually I should have said at the beginning, guys, the reason why we wanted to do this webinar is we look at the calls we get into the legal helpline, and without doubt this is the largest area, or the biggest area, sorry, where we get inquiries in. So it is great that we can put this on, and hopefully we can answer some of those questions now. So without further ado, what I'll do is I've made note of all the questions in the chat, so I'm just going to sort of pull them up. I'll go through in chronological order, so Charlotte might have to cast your mind back. We'll keep going for 5 minutes, guys, and then after 5 minutes, what we'll do, we'll have a cut-off, but I will share the questions with the team. We'll make sure they're all answered, and we'll put that into the email for you, so you do have sort of complete closure on those questions. But also just to remind you that there are the support mechanisms which Tom alluded to at the beginning, which again we'll put in the email. So first question, this is from Richard. Hopefully I'll get this right. So Acas code of practice designed for businesses with corporate functions. Clubs often have limited voluntary resources. Is it reasonable to be interpreted in the context of an individual club's circumstances? So Charlotte, or I'll just let you guys answer, whoever sees fit.
Yeah, I can answer that one. So you can flex it. So absolutely, it needs to be in line with the resources you've got available. I note the point that I agree that it may feel a bit like a burden for a smaller club where actually you've got to go through all these steps. I think the steps that we've broadly spoken about today are the minimum, but how the people you involve in the process, it may be that you're more limited, and that is absolutely fine. The tribunal, in dealing with a sort of claim, will take into account the size and the resource of the organisation. So you absolutely can flex it to some extent, albeit there are some minimum things that you need to do. If in doubt, as I say, get some legal advice, which you can do through the helpline.
Wonderful. Next question is from Simon Cartwell. Simon says, our disciplinary policy reflects its origins from playing and player issues. Can this exist separately from an employment and membership procedure, or should they all be in the same policy procedure? That's a really good question.
Yeah, so you probably will have different policies in those situations. So for your players, they're not going to have subject to this disciplinary policy, which is relevant to your employed staff. Your players may not be counted as employed staff, first of all. And obviously just different rules that apply. So you would have separate policies in that regard. Members as well, I think that came up on the question. Members, you might have a sort of policy for exclusion of members, but that isn't the same as a disciplinary policy for your employed staff. Matthew or Poppy, feel free to chip in if you have anything else to say on that point.
Yeah, it is tricky. There's quite a lot of questions about volunteers as well. I have to deal with them. Yeah, I think it probably is different, isn't it, if they're volunteers?
The risk is dealing with a volunteer through your disciplinary policy for employees is that you might start to be looking like you're treating them like an employee rather than a volunteer. So I think it just needs to be proceed with a bit of caution, get some legal advice if you're in doubt.
I think that the takeout is clearly have separate. Yes, yeah. From Linda, is there a time frame in bringing a disciplinary? We have someone who's been off on long-term sick and we've had to postpone the disciplinary.
Matthew, do you want to take that one? Because you covered long-term sick a little bit.
Yeah, it's tricky. If you want to bring a disciplinary along the lines of someone having done something wrong, then it can be tricky if they're off sick to go ahead with a disciplinary. Having said that, sometimes someone who's not fit to work could still attend a hearing. They may be fit to actually attend a disciplinary hearing where allegations are put to them. So it's not impossible to go ahead. But yeah, it probably would depend on the circumstances.
Thank you. This one's from Richard. At what stage should you suspend the subject or subjects of the allegation? And that's going right back to the beginning, isn't it? That was at 7:20. So Charlotte, that was part of your slides, wasn't it?
I can cover that one, yeah, exactly. So it shouldn't be a knee-jerk reaction. So the circumstances need to take into account. If you think the individual is going to interfere with the fairness of the investigation, that might be a circumstance in which you suspend them pending the outcome of that investigation. So it needs to be done more as a protective measure as opposed to just a knee-jerk reaction, or as opposed to looking like it's some form of disciplinary sanction. It shouldn't be used as disciplinary sanction. It's just an early way just to say, actually, because this matter is so serious that we think you being in the organisation, you being the business while the investigation takes place is going to cause us a problem. That limited period of time, you're on paid suspension whilst we investigate it. Hope that helps.
I'm conscious of time. We said we'd continue till 8:15. We're now that, and I know everybody's got busy lives nowadays and so on. So we won't get through all of the questions. So what we'll do, we'll put an end to the questions now. But as I mentioned, what we'll do, we'll share the questions with the team, and they'll help us put some context back and some brief answers back, and we'll follow all that up with an email which has all of that information. Sarah, I can see your question there. Don't worry, I'll make sure I collect that one and add that on. So guys, once again, so Poppy, Charlotte, Matthew, thank you so much for joining us this evening. Guys who are on the call from various clubs, again, thank you for joining us. It's super that you've given up your time for a topic which is, not necessarily a straightforward topic compared to some of the things we discussed, but it all will be recorded. Don't forget the legal helpline. Don't forget that there's a portal there with lots of documents and template documents for you to look at and use, and they're all free. So it's a great facility that we have to support you. So thank you very much for joining us this evening. Have a good evening, and look out for future webinars from us over the coming weeks and months. Thank you very much.